Yo, it's JP. I'm going to give you a couple pieces of EEOC and Title VII advice today, okay? So if you're in the EEOC process, if you think you might have a Title VII claim, you want to watch this video. I'm going to keep it very short and very to the point, all right? First of all, if you are involved in a race discrimination case, specifically race discrimination, all right? I have some very important advice for you. And before I give you that advice, I want to step back and I want to make a broader point about these types of cases, okay? A lot of times folks show up and they say, I was discriminated against, and it was because of my race and my age and my disability and my religion and 16 other things, okay? And folks, I'm going to tell you, does that happen sometimes? Well, I'm sure that does happen sometimes in a handful of isolated instances. But in the vast majority of cases, it's one thing, okay? It's one thing. And remember, the thing always is what the thing is, right? It's the one thing. When I see these cases where people say, I was discriminated against for 16 different things, for my race, my religion, my age, my disability, my gender, my this, my that, okay? The reality is that when I get those types of inquiries, I am inclined just to delete those and not even give it a second thought, okay? Because you weren't discriminated against for 16 different things, okay? Let's get real. It's the one thing, okay? The thing is what the thing is. So if it is a race discrimination case, okay, and you have to understand this from a standpoint of, I'm a lawyer. I own and run a law firm. We litigate lots of these cases, okay? But at the end of the day, we have to litigate cases where we believe we have a strong chance of succeeding. Why? Because we have to front, oftentimes, hundreds of thousands of dollars. And that's what folks don't understand. We have to front $200,000 or $300,000 or $400,000 of attorney time. People say, it's just the time. Well, the time's not free. The time's not free. Like, we have a 4-lawyer shop. Who's paying for all this, right? I'm paying for all this, okay? I'm paying for all this, and I am darn certainly not paying for all this if I think the case is bullshit, and if I think the case is not going to be winnable, all right? So the thing is what the thing is. And if it's race discrimination, then say it's race discrimination, and don't say it's 16 million other things, okay? So if it is a race discrimination case, you have better weapons or better tools available in the toolkit than Title VII. Many states, you take New York, New Jersey, California, okay? Those are states where the state law is much more favorable than Title VII. What do I mean favorable? Title VII has damages caps, okay? So if you file a Title VII claim under Title VII, which Title VII covers lots of different types of discrimination, but if we're talking about race discrimination, you have Title VII over here. Title VII is going to cap your damages, even for the biggest employer, the biggest company in America. Title VII is going to cap your damages at $300,000 on compensatory and punitives. You can get whatever lost wages or lost income, sure. But in terms of compensatory and punitive damages, Title VII is going to cap that at an absolute maximum of $300,000. Those caps have been in place since 1991. They have not been updated and are in no way tied to or indexed to inflation. It's preposterous, okay? But it is what it is. Title VII has hard and fast damages caps, okay? Guess what doesn't have hard and fast damages caps? 42 U.S.C. 1981. 42 U.S.C. 1981, the original Civil Rights Act, immediately in the aftermath of the American Civil War, okay? It is still good law. We're talking about a statute from the 1860s that is still on the books that permits you to get uncapped compensatory and punitive damages. And don't be looking at this and getting dollar signs in your eyes, because I have these people, right? And we get every week, hundreds of people reach out to our firm. And several of these people, every day, at least several times a day, we get these inquiries where people say, my case is worth $4 million. Yep. My case, I need $1.5 million in compensatory damages. I'm thinking $3 million in punitive damages. It's nonsense. You don't just put a number on your case and say what your number is, or say what the case is worth. Like the person who does that, the person who can evaluate that and tell you what the case may be worth or potentially is worth, right? That's a lawyer who has significant expertise in this area of law. And even then, that's only an approximation or an idea or a concept, because the case is only worth what? Case is worth what the other side will pay you or what the jury will give you. Okay? But be that as it may, 1981, 42 USC 1981 has no damages caps. What does that mean? Okay? Well, Title VII, in Title VII cases, you have to file a charge of discrimination with the EEOC, and you have to go through the EEOC process. But if it's a race discrimination claim, you don't have to go through the EEOC. So I see a lot of folks who are in the EEOC process, okay? Title VII claim, race discrimination, and they don't have to be there. And being there serves utterly no purpose. Now, historically, and this is just an extra data point for people who are interested in it, historically, it was understood that there was a different standard for proving liability as between a Title VII claim and a 1981 claim. So historically, it was understood or believed or conceptualized that it was easier to prove a Title VII claim than a 1981 claim. And that's why a lot of folks would hedge and go with the Title VII, because they thought it was easier to prove. It's not. It's the same exact standard, okay? It's the same exact standard. That means pursuing a Title VII claim in a race discrimination case makes utterly no sense. You do not have to go through the EEOC. You do not have to get a right to sue letter. You do not have to wait a certain amount of time. In fact, if you have a race discrimination claim, there is nothing to prevent you from just filing a lawsuit right away, right from the jump. Not only that, but you have a longer statute of limitations, because in the EEOC process, right, in many states, depends on what state you're in, okay? Depends on what state you're in. But suppose you're in a state where you have 300 days from the incident of discrimination to file an EEOC charge. Then you go through the EEOC process, you get a right to sue letter, and then you have 90 days to file a lawsuit. None of that applies to 42 USC 1981, okay? So if you have a race discrimination claim, it is not to your advantage to be messing with the EEOC, to be messing with Title VII. If you have a race discrimination claim, you should just be pursuing a race discrimination claim through 42 USC 1981 and bypassing the whole EEOC process, okay? That's point one, okay? I'm gonna make point two. These are not necessarily in the same exact arena in terms of the discussion of the analysis, but these are two things that I see coming up time and time again, right? One of the things that informs what I talk about and what I discuss, okay, is what I actually see coming in the cases, in the data, in the leads, in the inquiries, okay? I don't personally answer these phones and return these calls and emails, etc., but I see the top level. I have a sense of what's coming in. I spot check it just to get an idea of what's going on out there. And so a trend that I see is I see lots of people with race discrimination cases messing with the EEOC and Title VII when they shouldn't be. So that's why I made point one. Point two is about the EEOC more generally. This is not limited to race discrimination. This is more generally related to the EEOC and the EEOC process. Lots of folks contact our office and they're in an absolute panic because they have a deadline coming up in the EEOC, okay? And this generally comes in two forms, right? Where folks contact our office and they're in a panic and they say, I have a response to the other side's position statement and it's due next week, okay? Well, let me apologize for being such an asshole, okay? I understand it's a very important thing to you. I understand you take your case seriously and this is a big thing in your life right now, all right? But an EEOC deadline is a paper tiger. The EEOC itself is a paper tiger. EEOC deadlines internally are basically meaningless, okay? I'm not talking about right to sue. That's different. That's not an internal EEOC deadline. The right to sue, where you get 90 days, that is a hard and fast deadline for filing a lawsuit, or else your claims are gone, okay? That's different. I'm talking about an internal EEOC deadline, such as if the EEOC says, you have until next Monday to submit your response. There's no consequences if you do or don't, okay? You submit your response, now you can take another week, you can ask for another week, whatever, right? There's no punishment. There's no consequence. You're not going to lose your claims, okay? So I just want to clarify to folks that exactly that. You're not going to be punished in some sense or lose your claims or forfeit your right to pursue these claims, okay? That happens if you blow the 90-day deadline to file a lawsuit after you get a right to sue notice, okay? But internally within the EEOC is not a court. The EEOC is not a judge. The EEOC really has no power, okay? So if you need some more time, if you need an extension, you just reach out to your investigator and you say, hey, I need more time, I need an extension, okay? In that same direction, I see a lot of folks freaking out because they are set for an EEOC mediation, okay? Give me a second, I'm gonna get a drink of water, I'll tell you about EEOC mediation. So I see people freak out, they've got an EEOC mediation, and people, you have to be real about the world, okay? Every week, dozens of people reach out to our office and they'll say something like, I have an EEOC mediation 5 days from now, and I need a lawyer, and I want to know if JP can represent me. No, I can't, okay? I can't. Like, I can't, our firm can't, my colleagues can't, because there is no way on God's green earth that we are getting involved in a EEOC case and doing a mediation in 5 days. It just doesn't work like that. You have to be realistic, okay? But, and here's a point you take some solace in, okay? It connects with the prior point. The EEOC schedules a mediation. Who cares? Okay? Who cares? You can show up if you want, or you could tell them, no, you have to reschedule. Or you can say, hey, I need to find a lawyer to do this, and so I can't do it on next Friday or whatever it is, okay? And there's not going to be any consequences there. The worst that's going to happen is the EEOC will contact you and say, well, you didn't show up for mediation, so we're closing your case. We're going to give you a right to sue notice. That's the real consequence that can happen. And then at that point, you got 90 days, you're on the clock, and you have to file your lawsuit or find a lawyer to file it for you, et cetera, right? But this notion of like, oh, I have an EEOC mediation and I'm freaked out and I don't know what to do, and right? Like, understand, you can get that extended. You can contact them. You can say, I can't show up. I can't make it. I need a lawyer. Okay. The worst thing that you can do is go to an EEOC mediation by yourself, not represented by counsel, and get steamrolled, because a lot of folks end up having that happen to them. And it makes a lot of sense. Okay. They go to an EEOC mediation. There's a mediator there. The company's there with their representative. The company has a lawyer. You're not a lawyer. You don't have a lawyer. You're in there. You don't know how the system works or what you should do or not do. They put a couple $1,000s on the table and you wind up settling it. I have seen people, and again, the perpetual and constant caveat here is don't get dollar signs in your eyes, and don't think that your case is a slam dunk, home run, great case when a qualified, experienced, sophisticated lawyer hasn't evaluated it and given you any reason to believe in that direction, right? Don't do this, well, I think I have a strong case because, I feel very strongly about it, right? Like, no, this is not about how you feel about your case. This is about the facts and the law and an objective assessment of the case valuation, okay? So don't get dollar signs in your eyes. That's the perpetual caveat, but don't get rolled. And a lot of folks go to an EEOC mediation. They're not represented by counsel. The mediator's there. The company's got a representative there, and the company's lawyer is there. And as a layperson, you're not a lawyer, okay? You're in this very complex system. You're in an EEOC mediation, and you wind up settling your case for $5,000, $10,000, when the case is worth much more than that, I've seen that happen 100 times. 100 times. We've gotten tons of inquiries from people, and they reach out and they say something like this. Well, I settled my case at EEOC mediation, and then I watched your videos and I read your blogs and I did some research, and I feel like I just feel like, you know, could I have gotten more? Do I have any options? No, of course you don't have any options. Okay? Of course you don't have any options. You settled your case, you signed off on something, that's it, it's gone. You waived all your claims. Okay? I'm telling you is not to do that. Don't go to an EEOC mediation unrepresented. Don't let the EEOC roll you and force you into a mediation and tell you, no, you have to show up unrepresented by counsel, and then strong arm you into settling. Okay? If you're set for an EEOC mediation and it's coming up in the near future and you don't have counsel, you go to the EEOC and tell them, like, I'm not coming to this mediation. I need to reschedule. I'm still looking for counsel. Okay? And why do I say that? I say that because I don't want you to get rolled. All right? Does that mean I will take your case? Absolutely not. Absolutely not. We get 400 plus inquiries a week. I take cases very selectively. All right? Will we look at your case? Will we consider your case? Absolutely, we'll look at it. Absolutely, we'll consider it. Okay? Doesn't mean I'm going to take it. Doesn't mean we're going to take it. We can only take so many cases, and we have to be selective about them because they take tremendous investment, especially when I'm willing, right? I have a number of cases right now up on appeal in the United States Court of Appeals for the 11th Circuit. Okay? I got 3 cases right now up on appeal. Most plaintiff side employment lawyers don't do that. One, most plaintiff side employment lawyers don't do appeals. They don't do their own appeals. They are not appellate lawyers. Well, we are appellate lawyers, okay? We have won numerous appeals in the Florida state courts and in the federal appellate courts. We are competent, capable appellate lawyers. Most plaintiff side employment lawyers are not. They don't do appeals. They're not going to do that extra work. They're not going to put in the extra time and the extra money. They would rather settle something for much less than it's worth than pursue an appeal. We've even had appeals where we had a chance to settle the appeal. We've had a chance to settle the case during appellate mediation, because you always have to go to mediation, folks. Look at this, right? You go to EEOC mediation, you litigate the case in the trial court or the district court, you have to go to mediation there. You take an appeal, you have to mediate during the appeal, okay? The whole court system is flooded with mediation, right? Because they want everything to settle. There's all these off-ramps to settle because the courts are overburdened. There's too many cases. Judges have dockets that are too extensive. It's a whole structure built on trying to get everything to settle. And in all fairness, there are lots of cases that can be settled, and there are lots of cases that should settle, all right? But we have cases that we've taken up on appeal where we've had options to settle those cases on appeal and have still said no, because the client was willing to ride and accept the consequences, and we felt strongly that we would win the appeal, come back down and get to go to trial and get way more money on the back end, okay? But the point here is that EEOC mediation, it's not this, hard and fast deadline where you have to do it or there's some type of terrible consequence. You just contact the EEOC, you contact the investigator, and you say, hey, I can't come. I'm looking for a lawyer. I'm not going to come by myself. And you just kick it down the road until you find a lawyer, okay? Worst thing that can happen, they'll just issue you a right to sue letter. And then at that point, you've got 90 days to either find a lawyer to represent you or file your own case. Because here's the thing, if you can manage to put together and file your own case, you're going to give yourself several benefits, okay? One, you're going to preserve your rights. Because if you get a right to sue letter and you wait beyond the 90 days, your rights are gone. You have no claims. They're gone, okay? Vanished into thin air. But if you can put something together, even if you have to write it by hand, okay? Even if you have to write it by hand, take it down to the courthouse and say, I need to file this, and you pay the filing fee. It's $405, okay? And you can actually request the court's permission to have the filing fee waived, right? Like if you're in poverty and you don't have the money, like you can actually request the court to let you file it without paying the filing fee, okay? So at a bare minimum, okay? It's like folks say, it's like that old saying, right? Where it's like, if you can run, then run. If you can't run, then walk. If you can't walk, then crawl, okay? But that's how you have to do it, right? If you can't get a lawyer, You go down to the courthouse, you file a complaint yourself, okay? You Google stuff, you Google some complaints, you file your own complaint, and then you tell the court that you're asking for the court to appoint you a pro bono lawyer, all right? And the court will not order a lawyer to represent you, but many judges will put out a notice to lawyers who are members of the bar for that particular court. So say it's the United States District Court for the Southern District of Florida. Okay, say you're in Miami, Fort Lauderdale, West Palm Beach. Okay, the Southern District of Florida. There are hundreds of lawyers, probably a couple thousand lawyers who are members of that bar, and many of those lawyers subscribe to a list where they get notified of new matters where the litigant is seeking pro bono counsel. Okay, I get these all the time, right? Where it's like new pro bono case. Like, any lawyers out there want to do this case? It's a pro bono case. The client needs a lawyer, or the not even client. They don't have a lawyer. They're not a client. It's the person needs a lawyer. Are there lawyers who are in this bar, who are members of this bar, who will help this person pro bono? And so if you file your own case, right, you like come hell or high water, if you get it filed, you ask to file it without paying the filing fee, and then you ask the court to appoint you a lawyer or to request a lawyer to represent you for free. At the very least there, you're preserving your claims and you're giving yourself a chance to keep your case alive. And that's what you have to do, okay? That's what you have to do. You got to go. You're on YouTube right now watching this. You got to look up David Goggins, okay? Watch some David Goggins, all right? Whatever you can do, you got to do what you can do. And in this context, in this arena, you got to keep your case alive. Jonathan Pollard, just trying to help you out, give you some tips. Keep going, keep the faith. Road may be rocky, won't be rocky long. Have a good day.